Appreciate it. Okay, being the 8:30 hour, we are on the record, State of Nevada versus Meta Platforms, case 886-110, pages 1 through 3. Counsels for plaintiff, can you please make your appearances?
Good morning, Honor. Michael Gayan and Donna Springmeyer from Kemp Jones on behalf of the state of Nevada. Also with us on Zoom today remotely, I've got my co-counsel Phil Carlson, Michaela Holweiler, Brian McMath, David Sneed, Matt Bush, and Brian Moore. And then also from the Attorney General's office, we have Raquel Fulgham and Anthony Walsh. I believe I got everyone on our
And
team.
if any of those are appearances, we need to make sure they have put in the chat their bar numbers. Just, okay, remember, name, case you're on, party you represent, and bar numbers, so we can just make sure we got that record right.
Sure.
I'm asking you to go back through, so I'm sure everybody heard me, and I'm sure everyone's gonna take care of that,
And
right?
I do believe all of our remote folks are just planning on observing. Several of them have been admitted pro hoc vice, and I can't remember if I said Matt Bush.
But if they want to be shown as potentially being on the case for today, right?
Sure.
As having an appearance, we need to have either pro hocs, bar numbers, they're appearing and observing, just so we get clarity in our minutes. Appreciate
Sure,
it, thanks.
and I'll leave that to them if
Right.
they would like to put their names in. Thank you.
Okay, thank you.
I'm sorry, you said Michaela, somebody, I don't see that person up there, so we need to spell it.
Michaela Holweiler, she's
She's going to, I'm sure, put her name in the chat and spell it correctly,
I have-
right? Because that's what the court just asked.
got her picture up there still.
Okay, I got it, thank you.
Yep.
Okay.
Thank you.
Counsels for defense, go ahead, please.
Good morning, Your Honor. Tammy Peterson on behalf of Meta Platforms, Inc. With me this morning is Tim Hester, who's appearing pro hoc vice in this case. Also, Mr. David Sneed, who's the Sneed. I don't know why I just said that.
Wish you
That's
had
really
David
funny.
Okay, are you switching sides?
I was looking right at the screen when I said that, so there's my problem. Anyway, Mr. Sneed is admitted pro hoc vice as well. Also present is Dan Waite, who's here in the courtroom. There's no one else that's appearing on behalf of Meta this morning, Your Honor. There are a few people observing, but no one else needs to be listed in the minutes. Thank you.
Okay, appreciate it, thanks very much. Okay, so let's address the first issue briefly right before the record. As you know, public courtrooms, but people are more than welcome either remotely or in person. We knew about one media request, found out about another one today. And so what I just need to have a confirmation. I understand that counsels, you were served with a media request by the Review Journal, correct? And any opposition to having them also do what they need to do today?
Your Honor, Michael Gayan on behalf of the state, no objection at all.
Thank you, Counsel for Defense.
No objection, Your Honor.
Okay, so what the court's gonna do, because it just popped up, right, is the court had mentioned right before, is because this particular case has certain sealing orders with regards to certain documents, some of the documents of which are going to be addressed during today's hearing, okay? So what we're gonna do is, if either counsel says that they need to discuss something that is subject to that sealing order, we'll pause for a moment and find a game plan on what to do, okay? So we normally have been able to discuss things in a more general sense and just reference the redacted version of a document. Some are sealed and some are redacted, subject to Supreme Court Rule 3, applicable case law. But if that issue comes up, we will let both of the parties who have the media request, and you will see on the media request that I'm about to sign, that I just got. Under the other, it has that language in there. Does that meet the needs, our Nevada judges? I know I've asked this in the past on this. Does that meet you all's needs?
Yes.
Does that meet your needs for Las Vegas Review Journal, or are you requesting something different?
No, that sounds good.
Okay, perfect. Okay, so, speaking of sealing and redacting, there was a Meta Platforms motion to seal and redact the notice of compliance with the court's directive to submit proposed order regarding remaining jurisdictional discovery disputes, which is document 177. And that one, as you can appreciate, our wonderful clerk's office tries really hard, but nobody's perfect. That one appears not to have been set for hearing, but since it impacts issues that are going to be discussed today, if the court had asked my JEA to please put it on for today to see if the parties wished it to be addressed today, at least to give you a heads up. If either party requests that it not be heard today, then of course we'll set, the clerk's set it when it gets set. But if you all like the court to address it today, If there is a mutual agreement, then the court will do so. Counsel for medicines, it's your motion.
Thank you. Yes, Your Honor. I may be a bit confused. I did get a notice of hearing late yesterday for the motion to seal and redact notice of compliance with court directive to submit proposed order. So, and that I show is set for July 2nd.
Did that come from the clerk's office?
It appears to be signed by the deputy clerk of the court. It's really strange though, what I got doesn't show any sort of file stamp, it was just sent, so I'm not sure what happened.
Okay,
Yeah, Your Honor, I think I got the same thing, but
Okay.
there's no objection from the state to advancing it, hearing it, and granting it today.
is there a request to,
We would request that you advance that and hear it today, Your Honor.
okay, well, I'm not gonna speculate, but there is sometimes a situation when we remind the clerk's office of a hearing, right? They may have to take a few moments to, A, get our request with all the other requests. They may have done something after we already tried to proactively get it set for you all today. But regardless, since you're requesting it to be heard today, EDCR 2.23, a mutual agreement is advanced to today, EDCR 2.20. It is going to be granted, but is also granted on the merits, obviously, under a full review of Supreme Court Rule 3 and applicable case law consistent with what was set forth in the motion and looking at the history of this case and how this should be addressed. So that should take care of document 177. Does anyone need there to be a written notice of entry of order, or can we do the court's oral announcement from the bench? Division of Family Services and Rust versus Clark County meets the needs of the parties that it can be effective for today's purposes.
If that would be fine with us, Your Honor, that it would be effective for today's purposes, and I'd be happy to submit a proposed order as well.
EDCR 7.2. I'm just trying to say, I
Right.
didn't think that any of you all wanted me to wait the 14 days for the order, so I just was asking whether or not you all were both in agreement that the oral pronouncement can be viewed as an order so that we can move forward with your other substantive matters.
Yes, that would be fine, Your Honor.
Okay.
Michael
Deputy
Gayan
Attorney's
for the
Counsel.
state, we agree.
Okay, perfect. That was taken care of.
And I am confused about one thing too. We had a separate motion to seal notice of compliance regarding the remaining jurisdictional discovery, and that I'm not sure was on for a hearing or set for hearing. And I don't have the document number, I'm afraid.
One this court's aware of is document 177. So that's the one that I advanced to today, the titling of that. And give me a quick moment, I will go into the document as well, just to be cognizant of what the competing times mentioned. Okay, so that was titled Meta Platform Inc.'s Motion to Seal Redact Brand Notice of Compliance with the Court's Directive to Submit Proposed Order Regarding Remaining Jurisdictional Discovery Disputes. That was filed on 5/23, that's document 177. That's the one the court was aware of. And it would make sense with the intervening holiday that, remember, yes. Taking a look at the clerk's notice of hearing that just popped up that you mentioned is quickly, here's the reason why. There was not an OST attached to your proposed hearing, request for the hearing on that document, 177, which is why the clerk's office would have said it in ordinary course, which is why you would have gotten July 2nd. It's a general quick understanding of looking at this, but that one got addressed. So counsel, is there another motion to seal or redact, which is
Yes.
filed?
Well, Your Honor, and I was able to look up on Odyssey or whatever it's called. It looks like Meta filed, Tammy, is it the one on May 17th?
Correct.
Okay, that's document 168.
There you
That is
go.
motion to seal related to the charts. And then the state's motion to seal related to the chart is document 163, also on the same date, May 17th.
Thank you, Mr. Gayan.
Okay,
Welcome.
so with regards to each of those, did you all? Is that one good? Okay. Let me look at 160. Wait 1 second. Let me put hearing requested, okay. I'm not in charge of setting hearings, but is the request by each of the parties that the motion to seal document 168 also be addressed today? Is that a request under EDCR 2.23?
Yes, Your Honor, that would be our request, and we would also have no objection to 163 being heard today as well.
And the
We
state,
take these one at a time, but
Sure.
sure, the state requests similar treatment for 163, Your Honor.
I think those are set for hearing on June 20th and June 25th. Yes, June 20th is Meta Platforms, the one mentioned, it's regarding the jurisdictional discovery dispute, and the other one is set for June 25th. So the June 20th one, which is Meta's, which is document 168, the request of the parties, it's a request of defense, and no objection by plaintiff, it's advanced today, EDCR 2.23. And while you were talking, I was reviewing it, it has the same aspect, and so that's going to be granted both under Supreme Court Rule 3 and under EDCR 2.20. And re-reviewing this is one of the ones I had looked at in preparation for today anyway. I just saw it was on for hearing coming up, and that wasn't one of the ones I was addressing in that other regards. That's taken care of. Document 163, which is plaintiff state of Nevada's motion to seal and redact portions of its supplemental chart relating to plaintiff state of Nevada's motion to compel is currently set for June 25th. Counsel for plaintiff, was there a request with regards to that?
Yes, Your Honor, we would ask that it be advanced and heard and granted.
Counsel for a minute.
No objection, Your Honor.
Okay, we cite both the confidentiality agreements, Supreme Court Rule 3 is consistent. Yes, meets Supreme Court Rule 3, Parade 4. Yes. And as to be redacted is preferred over sealing, yes. Court is going to advance that EDCR 2.23, granted EDCR 2.20, meeting the rules of Supreme Court Rule 3 and consistent with the confidentiality agreement between the parties, and that would be the same analysis mentioned previously with regards to 168, and we already addressed 177. Okay, so, I'm hoping you advance and grant those. Perfect, thank you so much. Okay, so now we are going to go to, last time you were all here for a hearing, we were kind of combining the motion for the protective order with the motion to compel discovery. Is that the same process that you all wish to do today, or do you wish them to be treated as distinct, separate motions, and they have a lot of overlap? Counsels, let's find out what you'd like to do.
Your Honor, I think they can be addressed together. Michael Gayan for the state.
Yeah, Timothy Hester for Meta, I would agree, Your Honor, they really are covering the same ground in different ways, but yes.
Okay, so then we have defendants. Motion for protective order regarding jurisdictional discovery. The redacted version was 113. That was temporarily sealed, but subject to the court's ruling today. Sealed. The request for the order shortening time, document 115, NEO 117, certificate of service 120. Then state of Nevada's opposition, redacted 128, temporarily sealed 129. The reply 136, temporarily sealed 135. And the motion to compel, plaintiff state of Nevada's motion to compel discovery responses regarding personal jurisdiction issues, an order shortening time, document 99, appendices, document 101, under temporarily sealed one is 102. State of Nevada's motion to compel responses. 105, we've got the motion to compel the discovery responses regarding personal jurisdiction issues, 107, NEO 109, and they are, the certificate of service 111, opposition 123, reply redacted 131, notice of compliance is 164, temporary sealing is the 165, we addressed that a few moments ago. The Meta Platforms notice of compliance is document 166 with temporary seal 167. The notice of compliance by the defendant Meta Platforms regarding the proposed order regarding jurisdiction discovery is 175, temporary sealed 176. Okay, so pursuant to, thank you for the lovely charts and other information. What probably is the most efficient way to do it, I mentioned this briefly before we went on the record, is for the court to give you at least an inclination of some of what we discussed last time as kind of global concepts, and then walk through each of the discovery requests that kind of go to those global concepts, and if the court needs to make a more specific ruling, we'll address it therein. So, does that meet the needs of the counsels for plaintiff?
Yes, Your Honor, Michael Gayan for the state.
Does that meet the needs of counsels for defense?
Yes, Your Honor, Timothy Hester for Meta.
Okay, so, first one, and I'm looking at the Exhibit A, both the redacted and the unredacted version, and I'm just going to go through the global topic areas, so to minimize the issue with regards to the sealing aspect, if anybody does need to go into something specifically that was under seal or redaction portion of any said pleadings and no discussion, please let the court know in advance and we'll figure out a way to address that, okay? That work for everyone? Okay, so the first global dispute is with regards to the information about what's been called nationwide activity across the 50 states, not targeted as Nevada. And then there is also phrased as kind of more global decisions, been phrased a couple of different ways. The court's inclination is as follows. If there is a decision that impacts the state of Nevada, I'm going to take a hypothetical that has nothing to do realistically with this case. Let's say there was a decision to only provide a certain type of service to a particular group of individuals, okay? And that was, whether it was a global or a nationwide concept, but that it did specifically impact Nevada, then that the court's inclination is that would be subject to discovery in a narrow sense, meaning to the extent of what the decision was, right? If there was a document or an interrogatory response to what that decision was and that it did have an impact into Nevada. The court, in its inclination, is not saying that you would have to provide the documents for around the world or for every other state. But if there is a decision that is stated that it's going to apply to Nevada as well. Not so, because otherwise the challenge would be that there could be things that go specifically, we're talking in the jurisdictional discovery context, right? But we need to know what actually has been to Nevada, and it doesn't matter if it's a specific Nevada decision, but there may be various, as been stated, both nationwide and global decisions that would specifically impact Nevada. My perfect example I can't really utilize because it's another case before me, but say let's try and utilize another example. Say Meta was to add a new service, right? Call it a brand new service. It's going to have whatever name the brand new service was, and that was going to impact any state or entity that maybe allowed gaming, right? That would not be specific to Nevada, but obviously it would have an impact on the jurisdictional aspect because that decision would impact people who are the residents of Nevada and individuals in Nevada. So I was trying to take something that has nothing to do with anything that you all have provided, but trying to give you a highlighted example of what my inclination is. So that addresses a lot of these discovery requests, but I'm trying to be clear is that the court's not saying you'd have to say what you've done, like if there's been data and research for Arizona, or data and research for, it doesn't matter, Spain, okay? If there's data-specific research to Nevada, yes, that would need to be produced, but also the global one is the decision because it would have the impact into Nevada. That's a court's inclination. Since I'm really going to deal with this, last time we really let you each have 2 rounds of argument if you needed it, because I have both the protective order and the motion to compel. This court's inclination, remember today was just kind of for follow-up questions, etc. So I'm really inclined to do 1 round each, and then if the court has questions or somebody brings up an issue, then allow if the other side requests that they need to respond. Does that meet you all's needs?
Thank you.
Yes, Your Honor.
Okay. So counsel for the state, based on the court's inclination, do you have anything further that you wish to address to the court?
No, Your Honor.
Counsel for Meta, go ahead, please.
Yes, Your Honor, Timothy Hester for Meta. The question of decisions made that could impact Nevada, I understand what the court is articulating, but I wanted to follow up on the court's statement that it would be subject to discovery in a quote narrow sense. I think the court used the phrase narrow sense. The requests that we have from the state are for all documents relating to various subjects. So if we take a specific decision, take the court's gaming example, all documents relating to is going to be an enormous discovery proposition. So we would like to get clarity that Meta is not obligated to provide all documents relating to a decision. That will multiply the burden of the discovery enormously.
Okay, which is why I was trying to give my example, like you wouldn't have to provide documents, say you did some investigation of the impact, I don't know, pick any other state, right? I'm not gonna pick California because that wouldn't be a good example here, but pick Minnesota, right, it's got Indian game. Okay, so may fall in with my hypothetical and say that Meta did an analysis of what would be the impact in Minnesota, right, or had data on Minnesota. That would be excluded, it would not need to be provided. In addition, the challenge I really see, which I think you're articulating, is the fact that, does that mean every single email that talks about a decision, or does it mean every single document? Well, under our Nevada rules, all is not particularly since 2019, appropriate. So that one would be one I would see that you all might want to ask the court right now, kind of, the challenge with some of these are, and I'm trying to, because there's multiple requests, right, with topic areas, and it's a more efficient way, and it's really the way you all started to do this, but then I said, of course, I need to make a ruling interrogatory, right, an interrogatory, is why don't you explain to the court what you would see, your view of what that would require Meta to produce, and let's see if the state's in agreement, right? Let's see if there is an issue first. You know what I mean? The concept of all, no, too broad, 2019 changes to the NRCP. Yes, it's going to be modified, but that may not be the best help for you to just say that sentence, because you're going to say, well, what's the universal less than all? So that's why I'm trying to say, right, if there's going to be a decision, right? There's going to be the testimony previously, right? During the hearing, various witnesses were talking about how there were certain decisions in a paper, like on a decision, okay?
The articulation I might suggest, Your Honor, would be documents sufficient to show. Documents sufficient to show a decision that would impact Nevada, taking the court's reasoning at the front of what the court said today. If Meta is able to produce documents sufficient to show decisions it has made that would impact Nevada, even if they're nationwide, that feels much more manageable and reasonable than all documents. And I would submit that's a more effective way to go. It allows us to look for a specific document on an issue. For instance, one of the ones that we discussed last time was efforts to expand the user base. That was one of the specific examples discussed. Okay, if there's a new decision to take some particular steps to expand the user base, documents sufficient to show what that decision was, that seems more reasonable than all documents relating to, or any concept of any document that relates to a decision, because that really gets into an enormous volume of discovery, whereas if we can focus on, let's identify the decisions that we're talking about, and then we find the documents sufficient to show what those decisions were. That would be a way I would suggest that we could do it more efficiently.
Let's hear from the state.
Your Honor, Michael Gayan for the state. The concern with sufficient to show on something like this is, you typically use sufficient to show when you're looking for data or numbers. You don't need all, you just need the information itself. You don't need to show all the back and forth about the number or the data. And that's why, like on monthly active users, that we do have a number of RFPs that are documents sufficient to show, and we think those are appropriate for the information we're seeking on those. On something like this on a broader scope, and I know we're not talking about a specific RFP here, at this point we're talking conceptually. From the state's perspective, I think the way I would normally handle something like this is agree to a reasonable number of custodians that we search. And so it's not a company-wide search for everything. What is the decision? Who are the key people involved in that decision? And let's search their ESI and see, because if a whole team of 30 people reported to that one decision maker, then we'll get all of those related emails and documents by searching that one custodian or 2 or 3 custodians' inboxes. So I think that's a more reasonable way to make sure that we see the actual documents. On something like this, a documents sufficient to show would allow Meta to cherry pick and just show us the actual decision, the end decision, and none of the discussion about impact or the other things and reach and things that might relate to the court's jurisdictional analysis. So that's the state's concern on a document sufficient to show approach on something that's more qualitative than quantitative.
And what time period are you thinking?
Well, my understanding of the Meta's chart submitted on May 17th is that they're agreeing to go back to January 1, 2017. Our concern with how Meta phrased that in the chart is they said something like where reasonable and feasible to do so. I mean, that just is too subjective and allows Meta to
That's
decide.
why I'm
And so
asking you, what's the time frame?
it should be January 1st, 2017. The state's position hasn't changed. That's what we have in our chart. We understood that that was still in dispute. I think it is still in dispute with the qualifying language that Meta put on its new agreement to go back to that date. And I understand if documents don't exist going back that far, fine. But to say, I think they had 3 qualifying terms in there, and that's just not appropriate from the state perspective.
Please remind the court, had you all agreed to any PMK depositions? Because remember, there's potentiality of some limited depositions for the jurisdictional discovery. Have there been some names that have been agreed upon for any limited PMKs, or you all are right now at the written discovery and you're not going to do any depo? I'm trying to cross-reference with your custodian concept. I'm trying to see if there's a natural bridge that you all have already agreed that there's a few people that might be doing it, right? So that might be a way to go custodian route. Has that been addressed?
Yeah, Your Honor, Michael Gayan for the state. No, we have not discussed names of custodians. I think we're still at the scope of what this discovery is going to look like. And we've got 10 topics that are subject to these motions, and the court's rulings will probably help Meta understand which custodians or which individuals they should designate.
Your Honor, the plan ultimately had been, after we got through the written discovery, to have a 30B6 deposition. We had hoped it could be one witness. We still need to understand exactly whether that would be feasible, but that had been the intention, is to have one 30B6 deposition at the conclusion of the written discovery. If I could, Your Honor, just going back to this question of custodial searches, I do think it really expands the burden of this in a way that I don't think is necessary for the purpose. If we take the court's conception of decisions that could impact Nevada, it seems to me what we should be looking for then are the documents either that are sufficient to show or that directly reflect or in some other fashion allow us to avoid a broad-scale custodial search. There's a lot of potential employees of a 40,000 employee company who could be searched, and it's going to lead to a lot of burden that I think it goes beyond what is necessary to establish the record of the decisions that the court has articulated as appropriate for discovery here. So
You can appreciate why the court was asking the question, because you've already picked some custodians for 30B6. That might be a natural segue to really resolve this, and I appreciate why you may not have, but I'm trying to go if there was something. Okay. Well, the challenge was sufficient to show is excellent litigators are going to be right back before me on whether something's quote sufficient to show. So I am going to have to go custodian route, but realistically, I'm thinking 2 to 3 custodians, right? And I need time frame, counsel for Meta. What's your view on time frame? You've heard the state says January 1, 2017.
we're agreeable to that time frame, Your Honor.
The reason why I'm going 2 to 3 custodians, because I'm looking at the scope, and realistically, this is jurisdictional discovery. And so, in advance, those individuals would need to be prepped anyway for a deposition, whether it's 1, possibly 2 to 3. That's the reason why I'm going 2 to 3. For the topic areas, I was looking at the natural breakdown of who may be, based on the testimony that the court already has. It looks like there's a couple of people who are the decision makers. So if you do those custodians, then you really have minimized, consistent with Venetian and the NRCP, not only the scope, but then they would have to be prepped on some of the topics anyway for purposes potentially of a deposition. So I'm seeing that for when I'm looking at the burdens, right, doing the Venetian analysis. So 2 to 3 custodians that you all agree upon, back to January 1, 2017, if those custodians were employed at that time, right?
Understood, Your Honor, and we can meet and confer with counsel on what the decisions were and appropriate custodians and appropriate narrow search terms we don't want to go too far afield and make it burdensome. We do want to move the process along.
Okay, so really didn't want, I don't want the full explanation of what you all are requesting in the second prong after I get through this, i.e. coordination, but I do need to have at least a little bit of insight, because remember, my rulings today are based on the only case that is before this court. But if you all have some information that you've already discussed that you're going, depending on what you're requesting in the coordination request, that we're going to be doing this 2 more times, then I'd rather have a heads up now, because it seems to be more efficient to you all and more proactive, which gives you the inclination. The court needs to find out some more information on the coordination. I'm gonna give a heads up of where I'm going with the coordination aspect.
Your Honor, before we pivot to the coordination aspect, if I may, there's one other overarching point on the discovery that really affects how we handle it, which is...
That's exactly the one I was going to, which is why I was asking the coordination. It's kind of not to use the old colloquial chicken and egg, right, which one comes first, but your next broad topic, right, is whether Meta must produce discovery responses to requests seeking information for non-messenger services, okay? So that's kind of why I was saying I at least needed an inkling into where you all are going with the coordination, because I want to make sure that things are consistent. As we stand here today, this court only has 1 of those cases, and this court's only making its ruling on 1 of those cases. However, I wouldn't want to make a ruling that somehow implies, when I'm looking at what's currently before the court, that I am, in about 20 minutes, maybe asked to do something different and expand how many cases are before this court and making a determination. It seems to me we might be revisiting something, so I at least want an inkling of what's being thought, so that we are efficient here, right? Because if you're gonna ask me to do all 3 cases, then you're asking me to make a rule that they can't get the discovery on the other 2 that you're gonna potentially ask me to take on. You can appreciate that seems a little that may be inconsistent depending on what you all are thinking. So I don't want the long version, I just want the short version of, can we discreetly move forward with this? Because the next topic is the non-messenger. Go ahead.
Your Honor, Timothy Hester for Meta. The reason this jurisdictional discovery question has arisen is in relation to a preliminary injunction motion that is directed only at messenger. And so, as the court will recall, that was our principal argument against a preliminary injunction, that the jurisdictional issue had to be resolved first. And since the only injunctive relief being sought is in relation to messenger, that it seems to us we should proceed in relation to this question of jurisdictional discovery as to messenger only, because that's the only live issue on jurisdictional discovery right now, is the question of the preliminary injunctive relief being sought by the state as to messenger.
But you also have motions to dismiss, which trigger this whole jurisdictional discovery, right? And so
Yes.
that's where I was kind of heading, if you're going to be saying, as long as it's clear that the ruling today are for the only case currently before this court and doesn't get viewed as being expanded, and it means both of the parties need to address these in that current context, fine. I just didn't want to go through all of this, and then the next step, you all discuss your request for coordination, that okay, now let's reopen all these things. Somebody's gonna tell me, well, everything you just ruled on, Your Honor, we now have to reopen because of the potential with coordination. Do you see where I'm going?
I entirely understand the court's question. I entirely understand. It seems to us that there's two levels of answers. One level is that the resolution of the motion to dismiss as to Messenger, in other words, the resolution of whether the court has personal jurisdiction over Messenger, in our view, would be, at the very least, either dispositive or quite illuminating in relation to any separate questions of jurisdiction as to the Facebook and Instagram complaints. So that's one level, that it's not obvious at all that we're going to be doing this 3 times, Your Honor. But a second level is that the custodial issue the court framed up, 2 to 3 custodians, that doesn't work if we talk about all 3 services. It really multiplies the scope of the discovery, and it seems to us that the objective has been to have a narrow scope of discovery to resolve this injunctive relief question that is before the court on Messenger. And it wouldn't work, it would really multiply the discovery significantly if we're talking about all 3 services. And that's one of the principal reasons we've been aiming throughout, to focus this on the only issue that's in the complaint, that is the subject of the preliminary injunctive relief.
You are highlighting why I added the coordination topics to today rather than signing your stick as is, but, okay, Councilman, state your position.
Yeah, Your Honor, Michael Gayan for the state. I guess I would say a couple of things procedurally. It's a good question from the court. If the court does order coordination, I suspect there will be motions to dismiss in the Facebook and Instagram cases. Meta's counsel has asked that they be given an extension to file such motions until after the court rules on the Messenger motion to dismiss. The state has not agreed to that long of a delay, so it's kind of an open question on that issue, procedural timing of motions that will get filed. In response to counsel's comment about the injunctive relief, that is not the scope of the jurisdictional defense here. It's been raised in the motion to dismiss in this case, and it requires the court to look at the entire complaint. And as we talked about under the Ford case, there need not be a direct causal link between the contacts and the harms alleged for the court's analysis. So to say that this jurisdictional discovery is limited to the preliminary injunction motion and end-to-end encryption, I think is factually and legally wrong. So the court needs to look at it more on a global context, and that is the context that the state is asking for the non-messenger platform, specifically because, as we put in the papers and argued last time, Messenger, by Meta's decision, is integrated into Facebook and Instagram. It is a part of both of those platforms as well. And so I certainly hope that, based on how things go in this case, and the state does agree that for purposes of today, the court should only be considering this case and the scope of this case, not just the injunctive relief, but the full scope of the jurisdictional analysis that Meta has forced this court to do because it's raised this defense. But I'm hopeful that if the court does order coordination, we can avoid going down this same path and having the court do all of this same work. But I would say that the jurisdictional analysis for Facebook and Instagram might include a broader look than just what we're doing here today. So, but I would imagine, with experienced counsel and a sophisticated party, if we got rulings from the court today, maybe we could come to some kind of an agreement on the other cases, but I don't know.
As you may recall, on the coincidental nature of things, you had the case before the court yesterday, right? Involves a global aspect, is Meta platforms, right? It's not specifically Messenger, it's not specifically Facebook, it's not specifically Instagram. And you may recall the court did ask a question earlier on, because in that case it has its own issues in the courts. Got a pending ruling, so obviously I'm not going to go into any details, but in that case, there was not contesting a personal jurisdiction. And there was and I appreciate, it's a totally different case, I'm not in any ways, I mean, it's a trademark case, so I can't go into too many details, like I said, Penny Miller. But yet, that highlights the issue, right, of the court having to look at, do I look at this as a entity-wide, or do I look at it corporate structure in the I'm gonna just use for ease, I'm gonna say sub-companies, right, that make up the larger entity, because that's really you all's dispute in this next global topic. And let me tell you where I'm heading. Where I'm heading is, we both agree that the only case before me right this particular moment is Messenger. So I have to look at what Messenger is and what is going to be necessary for jurisdictional discovery in Messenger. So I'm going to address the request seeking information to non-related messenger services. Here's the court's inclination with regards to that. If there's things, am I going into bumps and pickles and things? Okay. If there's bumps, then that is going to need to be provided. I appreciate this is going to be an interesting way to kind of parse this out. But the state has the appropriate aspect for jurisdictional discovery for purposes under the nation, under the NRCP and other applicable case law, that it is entitled to some information with regards to if it's not titled as Messenger, but Messenger is utilizing information targeted to Nevada, the court would need to evaluate that under the applicable case law for purposes of personal jurisdiction. However, got to be careful, at least at this juncture, that this department only has one case, and to ensure it's only jurisdictional discovery in this one case, because I do not have an agreement of the parties to have jurisdictional discovery in all three cases. If you all had said, guess what, we think it's easier, might as well get it all over now and address it, then that would have been a different response from the court. Since I have an objection, I have to focus on this case before this court at this time. So, does the custodian aspect work for this topic? And then I'm going to go into your specific RFPs, because RFP 1 goes to both of these topics. That's what you've got. That's the reason why I'm kind of go topic, and then I'm going to go to specific RFPs and interrogatories. Does a custodian type approach work here for looking at information? Because I've got to keep it to jurisdictional discovery, and I've got to keep it under Venetian, right? So it's not overly burdensome for the issue that is before the court. So if it doesn't, I'm going to ask you what's your alternative, because there's going to need to be something in order to address that issue. Because whether it's a direct contact or it's the indirect contact, case law says the court's going to evaluate for PJ, for personal jurisdiction. So go ahead, please.
Your Honor, Timothy Hester from Meta. So I think I understand how the court articulated it. If there's a program or a decision or a project that's being used by Messenger, whether it's titled as Messenger or not, we understand that would be within the scope. But what we wanted to confirm is that matters that are unrelated to Messenger, that just involve Facebook or Instagram, would not be within the scope. And going then to the court's custodial question, 2 to 3 custodians will work if we apply this approach, if it's focused on Messenger or things being used by Messenger, whether they're titled as Messenger or not. But if we expand it to include Facebook and Instagram, it doesn't work. We would need many more custodians, because the custodians who are focused on Messenger are not going to have the relevant information as to Facebook and Instagram. But as I understood the court's articulation of the point, I do think it would be workable if we could approach it in terms of program services decisions that relate to Messenger, whether or not they have the heading on the page Messenger, but if they relate to Messenger, then I think we could have the 2 or 3 custodians that could cover the ground.
Program services, what's your third word?
Decision.
Program services and decisions.
Sorry, go ahead.
I think that would be workable, but I do think the custodial dimensions of the discovery would expand significantly if we don't have that limitation.
Okay, counsel for the state.
Your Honor, Michael Gayan for the state. The challenge is the documents show, and we've argued this
Right.
before, the documents show that Meta's goal is to obtain primacy in the messaging space. And part of that strategy appears to be integrating Messenger back into Facebook and Instagram, which have many more millions and millions of users. And so bumping users on Facebook and Instagram appear to be designed to get them on the platforms that now have Messenger integrated. And so people will then message on Messenger so Meta can obtain messaging primacy over Apple iMessage or other messaging apps. So that is a deliberate company strategy from the state's perspective on the discovery that we've obtained to date. And so saying that only bumps related to Messenger are relevant here, especially when the jurisdictional analysis goes to Meta's contacts with the state and directing potentially millions or tens of millions of bumps into the state of Nevada, whether it's on Facebook, Instagram, or Messenger related to those different platforms. The analysis, these facts are all relevant to the court's analysis, particularly because if the court looks at the state's complaint, Facebook and Instagram are discussed extensively, particularly in the context of Messenger's integration. So this is not a siloed Messenger case, even though those are the design features and harms and things that we are talking about in this case. Certainly the scope of what's relevant and Meta's contacts with the state of Nevada go beyond just the Messenger platform in and of itself under the unique facts of this case.
But the state has chosen to file 3 separate lawsuits, and doesn't this court have to look at that fact, that this is not a BuzzStew analysis where you're saying, well, guess what, we follow, this is a BuzzStew complaint, and so they're on notice, and we know it goes to all 3. Here, there are 3 distinct complaints. Now, and remember, even if I prospectively looked at what you're gonna ask me, I'm gonna have to be cautious and balancing some time. We need to move this a little bit more. Is even there you've asked for coordination. At least you've labeled it coordination, right? Not consolidation. And so that's why the court is having to focus on that. Bumps was an example. Okay, Bumps was one, you all argued Bumps for a while last time. So Bumps was easy with Bumps, okay? That would be an example. See what Meta is discussing, if I add the word policies to it, right? Programs, services. Well, what words would you use? And then I would add policies. Council, so Council for the State, what words would you use?
Excuse me, where are you looking, Aaron?
Council for Meta gave a suggestion, right, of involving certain things, right? Programs, decisions, and services, right, of Messenger. That's broader than Bumps, okay? I don't think anyone's thinking I'm just saying Bumps, I'm not. Bumps was an illustrative example, okay? So I would at least add the word policies to that listing because obviously policies are oftentimes a large component, right? And policies address some of the issues that the state's raised. If you don't like those words that Meta suggested, I'm asking what words you would suggest.
Your Honor, I would suggest adding policies to Meta's list, and that should be sufficient for the state's purposes.
And Your Honor, just to be clear on the specific example that Mr. Gayan mentioned, I think if Messenger is using bumps on Facebook to build its user base, then it's going to be responsive. I mean, it seems to me that that's within the scope of what we articulated, that if Messenger is engaging in activity to build its user base through Facebook, then we would respond. That would be responsive under the conception I provided.
Well, and Your Honor, to your question about the fact that the state filed 3 separate complaints, I would respond that this is a single company operating several of the world's largest social media platforms and leveraging using one to leverage growth in another and vice versa. And so they are choosing to integrate these and use them, although they appear to have separate teams. As we discussed last time, those teams work together, the Facebook team, the Instagram team, the Messenger team. They use resources across teams because it's a single company. And so they exploit their advantages on one platform to help grow their share and number of users and the number of daily active users on another platform. So this is not, although the state filed them as separate complaints because they're different platforms, and without getting into too much detail, I think Meta would agree, based on the coordination stipulation, it would be difficult to try all three platforms in a single case, and so that was one of the factors that went into separate cases. Just as it may not be manageable to try all together, but the fact that the state separated them doesn't change the scope of what's relevant in discovery based on the allegations. The fact that Meta is a single company using teams from each platform to leverage and maximize the growth and profitability of each distinct platform. And as it relates to this case that Your Honor has in front of you today, and we agree that your decisions should be limited to what you have in front of you, the evidence and the allegations in the complaint overwhelmingly shows that Meta uses its advantages in the Facebook and Instagram platforms to help it grow the Messenger platform, and they use employees from the Facebook and the Instagram teams to help grow the Messenger platform. And that's why the state is seeking information related to Messenger, even from teams with Facebook, Instagram, or their other platforms, as we've previously argued. And that's why it's all relevant, and it goes to the jurisdictional analysis, because it's not just Messenger. Under Ford, it's not a causal connection, so all of that together, you've got to look at the company and its context with the state, and that's why these other platforms are important, and it shouldn't just be a myopic Messenger view on this discovery.
Okay. So the court finds the appropriate blend and balance under the NRCP, applicable case law, is that there is some overlap. And so I find that it's made that we need to be a two-step process, but we'll see. Hopefully this works out from the first, that by having programs, services, decisions, and policies that either directly or indirectly impact Messenger meets the needs and is the appropriate balancing test, so that it's not too broad to go into separate cases, but at the same time allows for jurisdictional discovery to get that information. Same time frame, January 1, 2017, is there any discussion on that?
No, Your Honor.
That meets your needs as well, the state, right?
Yes, Your Honor,
Okay.
thank you.
So I've given you a temporal component, giving you a scope component, that takes care of that. So let me then, what that means is for RFP number 1, I'm gonna go to some of the ones that address these as issues, and see if we've taken care of everything. For RFP number 1, the motion to compel will be granted in part, denied in part, consistent with the court's just analysis with regards to the nationwide activity and the separate entities activity. Similarly, the motion for a protective order would be granted in part, denied in part, consistent with what the court just stated, both for the temporal component as well as the scope with regards to that. Does that meet your needs for RFP 1? Anything else need to be discussed on RFP 1?
No, I don't think so, Your Honor, thank you.
Anything else on the metas on RFP 1?
No, Your Honor, thank you.
Okay. RFP number 2.
Actually, Your Honor, I apologize, Michael Gayan. I'm just looking at the state's chart. There was also the under 13 users dispute, and I don't know if the court was going to get to that issue, but the way I understand Meta's position is that they want the court essentially to make factual findings that.
I'm sorry, Mr. Hester, it's your.
Since you have counsel, you have counsel flipping through the pages. Sorry, the microphone's going to pick that up versus you speaking, so.
Very noisy paper. It's very close to the mic, so I understand.
Yeah, no,
Thank
it's a
you.
unique thing that happens. Go ahead, please. Just want to make sure you get clarity. Go ahead, please.
Yeah, but I guess I'm looking at interrogatory 1, so I may be speaking out of school, and I
I
apologize
saw
if I
those
am.
wrong,
But to
not
the,
RFP.
Mr. Springmeyer showing the RFP 1 also has the U13 issue. So we've got everything but the U13 that the court has already resolved, and the U13 address touches on a number of them, so I don't know if the court was planning to make a ruling on that, but that is a dispute that impacts RFP 1.
Okay. Okay, let me go cross-reference with this one. You all started with the ROGs, they started with the RFPs, so I gotta send back to your RFPs. I think it makes more sense to address the under 13 when I get to ROG 1, because they're more specifically detailed there versus, because your RFP 1 is the documents related to the ROGs, right? So I was just circling that. When I get to ROG 1, we'll address that, and then I'll just say it's consistent with RFP 1. Does that meet both parties' needs?
Yes, Your Honor, that's certainly fine. I just didn't want to leave the issue based on your question on RFP 1.
No, it's, okay, thank you, I appreciate it. Okay, so you haven't waived it, we'll reserve that. RFP 2, the court's inclination is granted in part and denied in part, consistent with what the court just stated with regards to RFP 1, with regards to the non-messenger services, which is addressed in both of you with regards to as being the issue here, because time you've agreed on, so that's no longer an issue, and that's in the states. Your last one is time, right? And you have a comment about to overrule the objections and to reflect the modified scope of the meet and confer agreements. Counsel, can you just explain that a little bit more, what you meant? Would you still need court's resolution on that, please?
Yeah, Your Honor, it's just the overbroad, unduly burdensome, and not proportional objections that we're asking to be overruled, and including the platform objection and the time objection. So I think the court's rulings on the two broader concepts or categories resolves things, assuming the court is applying those rulings globally. That would resolve RFP 2 and 3, potentially, it looks like 4 and 5, and
Right.
we can maybe go down the list.
Yeah, it looked to me like it pretty much resolved a lot of your specific RFPs, which is why I went to kind of global context, and now I'm going straight into the RFPs.
Yes.
Other than your under 13 issue, which I'll circle back to in the ROGs. Counsel for Ben, is there anything else you need on RFP 2?
No, Your Honor, I was going to say the same thing. I think the court's guidance on these two overarching issues really gives us the answers that we needed on almost all of these.
Okay, well, I can do it the shorter version. Which ones do you think are still outstanding? Because I can say that my ruling will be consistent there with regards to RFP, and you can fill in the blanks, and then I can circle back with regards to the under 13 issue, or I can go them one by one. I mean, realistically, it's your time, folks, and I'm trying to balance everyone's time.
Your Honor, being respectful of your time, just flipping through the list, I think your rulings so far today address RFP all the way through 8. Number 9 has one extra issue, is that in the state's chart, there's kind of a descriptive in the rightmost column in disputes.
Correct.
There, but then 11 has another similar standalone dispute.
So should we go to 9 then?
Yes.
Both parties agree that the court's incorporating its analysis for RFP 1 into RFPs 1 through 8, subject to going back to the under 13 analysis and consistent therewith, granted in part and denied in part, both for the motion to compel and the protective order, or do you all want an RFP by RFP analysis? Counsel for the state?
We're happy to move along to the next live dispute, Your Honor.
And Your Honor, for Meta, I think the court's guidance on these two overarching issues gives us the answer on all of these issues in dispute. And I think on the under 13 users, just to cut to that one, I think it's going to be encompassed within the articulation that the court provided: programs, decisions, services, policies. that's gonna be picked up as long as it's confined to Messenger. I think that we understand that, and it would pick up the under 13 user point that the state is raising.
I'm hearing what you're saying, that the state will have an opportunity, right, to present their position on under 13, because I did say it specifically. So are you fine with moving to number 9? Did I
Yes, sure.
incorporate 1 through 8? Okay,
Yes, sir.
thank you so much. Okay, so now number 9, the additional issue that is to provide, plaintiff is asking the court to order defendants to provide agreements with marketers and advertisers regarding specific advertisements to Nevada customers, not merely Meta's general terms of use, privacy policies, and marketing policies. Now, here we might be overlapping with some things that are subject to the confidentiality agreement and the court's sealing. So if you need to discuss this in a more global context, feel free to do so. But what's at the heart of what's not being produced? Because certain agreements, right, how much, I can see certain marketing advantages and certain detailed points are not gonna be appropriate in this court order in jurisdictional discovery, right? The fact that they may allow, let's go back to my gaming example, right? If they had a marketing deal with the gaming entity, right, because of betting being allowed in the state of Nevada, then I can see that concept there. But how they've triggered their deals on a per click, right, or a per message, and how they've done that can have some proprietary concepts that you all already agreed to proprietary concepts in your confidentiality agreement, right? And so, but there's a balance of how much of that is needed for jurisdictional, right? Do they need to say it's marketing in excess of X or Y amount? Not necessarily a deal by deal and all the nature of the specifics. So let me hear what the state's really focusing on the nut of what you need, and then let me hear Meta's response.
Well, Your Honor, if it's all right with the court, I would, on behalf of the state, would like to hear from Meta whether they dispute how we've described what we're looking for here, and we don't actually know what they're doing exactly, and so it's hard for us to say exactly what we're after. But, you know, I guess
I can ask Meta to go
these sorts
first.
of
I can ask Meta to
activities.
go first if you want.
Sure, that would be
Councilman,
my.
do you mind going first? I'm sorry, I didn't mean to talk over you. Go ahead, please.
Happy to explain our position, Your Honor. We've provided the state with a full list of all of the third-party advertisers who have locations in the state of Nevada.
The advertisers have locations in the state of Nevada, or they are advertising to the state of Nevada?
What we have is the information on the entities that are based in the state that have advertised on the platform.
So furniture company X?
Yes,
Okay,
bowling alley Y.
okay.
So they have gotten that information on the identities of the third-party advertisers. They've also gotten the information on the revenues.
Okay.
So this seems unduly burdensome to us in relation to jurisdictional discovery to produce all specific documents, all specific agreements. It goes beyond the purpose. I don't think there's a realistic dispute about the proposition that there are third-party advertisers based in the state that spend some amount of money with Meta and that have advertised on the services. So we provided that information at that level. Going down into this more granular level doesn't seem proportional to the jurisdictional question. I know the state is arguing that one of the reasons that they think there's personal jurisdiction here is this advertising activity. They have the information to establish that point. We don't think, in fact, that's a basis for personal jurisdiction, but we'll fight that out later. They have the information they need to establish the proposition, and going to this granular level is burdensome and not necessary for the purpose. That's our position.
So you disagree, because remember, this is saying they want more than the general terms, use, privacy policies, and marketing policies. Are you saying they actually have specific information?
Yes, Your Honor, they've been provided the names and the addresses of all of the entities in Nevada that have advertised on Meta, on Messenger, and they have been provided,
It's just huge.
they've been provided with the revenue figures. So I would think insofar as the state thinks that advertising activity is a basis for personal jurisdiction, that's about as deep as we would need to go for that purpose.
Counsel for the state,
Yeah, Your
do you
Honor,
agree or disagree that you have been provided the advertised? I just need the clarity because your column's different than what I'm hearing.
sure, and I actually just asked my co-counsel to help me get the answer to that question, so maybe I'll start with something else and see if they get back to me. But from what counsel just said, they've only provided, even assuming it's accurate, which I will for purposes of my argument until I hear otherwise, they've only provided advertisers located in Nevada, not what the court asked. What about advertisers located outside of Nevada who are trying to target Nevadans? There are plenty of companies that are not based in Nevada who advertise, clothing companies, who knows, whatever they are, that you see ads on your apps and on your phone. They're not Nevada-based businesses, but they're targeting Nevadans, trying to generate business from Nevadans, purchases and otherwise. And so that is what Meta has not agreed to provide. So far, based on at least the chart, all we have are these general terms of use and privacy policies and marketing policies. We do not have all of the information. Sorry, Mr. Springmeyer is showing me something. Okay, so it looks like we did get a supplemental production. This is even in our chart on RFP 9.
Yes, Kristen?
Our version on RFP 9, documents 1 to 471. So we do have some information. I don't know exactly.
Wait, counsel, let me make sure I'm looking at the same updated. I'm looking at page 20 of 46.
That's right. And in the middle response column, Meta's supplemental response.
So disputes is not updated with the supplemental response on this one, is that what you're saying?
No, it is, and I believe this production of 1 to 471 from prior discussions with my co-counsel is really just these general terms of use, privacy policies, and marketing policies. I have not heard a report from anyone, and maybe I missed it, but I do not recall hearing a report that we got the information from Meta that Mr. Hester described. It's possible it's in there, but that's not been reported to me, and I'm waiting to hear otherwise, but
You can
I
appreciate
think-
I need that detail, right, you know what I mean, because I need that detail.
Your Honor, is there any objection if someone on the Zoom has that information?
Counsel, do you have
to
any
just
objection
provide
on
it
that side?
directly?
No objection, Your Honor. I'm making a representation to the court and to the state that is correct. Namely, we've provided the advertising revenue, but I'm certainly happy for the state to confirm it.
Sure, but I know we've received some ad revenue information, but the question is whether it's limited the way counsel described to the advertisers located in the state of Nevada versus advertisers located anywhere who have chosen to target Nevadans. And that's really the analysis. What are Nevadans being targeted with through Meta's services?
Your Honor,
Two different analyses, right? The first question is, do you have more than just terms of services, et cetera? Because Counsel for Meta has stated that you've got the advertisers and revenue for people listed in Nevada, and I think he's about to show you something. The question becomes whether that is sufficient or it needs to be broader.
So, Your Honor, the two pieces of information we've provided to the state are first, the advertising revenue that Meta has received for any entity anywhere located that is advertised into Nevada.
Wait, I'm sorry, can you just clarify that? Because I'm
Yes.
hearing that a little bit different than
I'm
the first
sorry.
time. The first time I was basically thinking of a furniture store that's only located here in Nevada, okay?
So we've provided them that information too. The furniture store, the bowling alley in Nevada that advertises on Messenger, they've been provided a list of all
Sure.
of those entities for the entire time period.
And you said in revenue, right?
Yes.
Okay.
Second piece, revenue, would be any entity located anywhere.
So let's take Super Bowl ads.
Yes.
Sorry, it's an easy example, right? You're watching before all the different streaming services, okay? Watching Super Bowl ad, right? There's the national ads, and then there's the targeted local market ads. So parallel that to what you've provided here, because they both get shown in Nevada, right? You get
Right.
to see, you know, I'm not gonna pick any ad because it's probably, case is probably in front of me in some other context, but, okay, national ad and a local ad, right? So you're sitting, you're watching the Super Bowl, you're watching the halftime show, you get to see, okay, old school, you actually watch, fast forward, okay, you're watching the commercials. So you have provided the local commercials, I'm hearing you saying,
Yes.
and the revenues of that. How about the national commercials?
Not the national, it was the advertising activity focused on Nevada. So it could be a national company, Procter & Gamble, deciding to run an ad for targeting Nevada residents. That would be picked up in the revenue figures. So it seems to us that if
Okay, so
advertising,
revenue, okay, sorry, go ahead.
so if advertising is important, these are the two dimensions. How much revenue have you generated from advertising targeted into Nevada? And are there third-party entities that have advertised on your service? And we've provided those two pieces of information. It's reflected in it's summarized in our opposition to the motion to compel discovery.
Right.
It's on page 6 of that paper, but we provided that information. And so our point now is it's not necessary to go advertiser by advertiser. That's not really going to be the way jurisdiction is going to get decided here.
Council, could you confirm you've got revenue dollars, any reason to dispute that?
I believe we do have revenue dollars. The problem is it's limited to Nevada-based businesses, and that's one of the issues. It's not all ads.
I'm hearing two different things. It seems to me that you all might need to spend a moment, because is the dollars, I'm hearing one side targeted to Nevada, but then separate apart, it is Nevada-based businesses. So are those revenue dollars only reflected for a Nevada-based business that has spent dollars on Messenger, or is it two separate numbers? I need a clarity on what
Sure.
that is, because that's really gonna be potentially determined.
And while we've been talking, to council's credit, he shared his hearing binder with Meta's brief where this was described.
Right.
And what I just saw in that brief was that its business is located in Nevada, where it's a self-reported address located in Nevada. That's what Meta gathered and provided. That was the list of advertisers where businesses self-reported a Nevada address. And then the revenue was, I believe, pulled from that list of advertisers, how much revenue was generated. So the state is asking for additional advertisers who advertise in the state of Nevada. The other thing that the state is asking for here, that co-counsel helped me articulate, is that Meta's terms of services that have been provided or are publicly available say that they give reports to advertisers that include information to those advertisers about specific users who have viewed their ads. That information includes the user's location, and those are the types of reports that the state would like to know, that Meta provides this information in reports to potential advertisers, to advertisers who do purchase ads through Meta, and they have it. It's and this burden objection, again, I don't want to belabor the point.
I need to.
But there's no facts to support any burden, and that's contrary to law, so it's boilerplate. But
Do you have you provided, and do you have first, is the way I should phrase that? Do you disagree that your terms of service say that you provide advertisers with data that lets them know, hey, look, in Nevada we've been so successful, X number of people have done it, so therefore you should re-up your ad?
Well, Your Honor, I don't have a basis to disagree with that statement from counsel, but I think the point is we provided the aggregate information. In our response to request number 2 from the state, we said Meta will produce its annual revenue figures derived from advertisements displayed on Messenger to consumers that Meta reasonably believes are in Nevada. So it's all advertisers. So we've given them the revenue figures on all advertisers. And then in response to request 3, we said Meta will provide information on the third-party advertisers that have placed advertisements on Messenger and whose self-reported address indicates they're located in Nevada. So it's both.
Let me tell you what the court's gonna do, because I appreciate, I'm trying to give you a lot of, but realistically, to the extent, if it exists and it has not been produced, data points that show for advertisers, whether you're calling it clicks, whether you're calling it views, right? for Nevada, the third parties that's been utilized, and those are already compiled, then those need to be produced as a supplement, okay? Because from a burden analysis, you already have them. Your terms and service say that you're already providing it to another entity. You're just giving it to the state of Nevada, and it wouldn't be, I see under Venetian, it wouldn't be an additional burden because they're already provided and they're already available, and they are going to show what actually is from the opposite end, right? The user aspect to say that you are already marketing in Nevada. So to the extent that those exist, those need to be supplements. That means for RFP number 9, granted in part and denied in part. So it's granted extension, we need a supplement from the additional things, the representations of council or meta of what's already been produced, plus additionally the terms of service will state as far as reports that are provided to advertisers, we also need to be provided to the state of Nevada. Don't say it's burdensome and Venetian, that means your protective order granted in part and denied in part with regard to RFP 9, yes, goes back to January 1, 2017. If those reports exist back to that date, council, go ahead.
And just to confirm, that would be in relation to Messenger, Your Honor.
That is in relationship to Messenger. Subject to, now I'm not narrowing the court's prior ruling, right, with regards to decisions, et cetera. That applies to all of these, but I'm not expanding it or narrowing it, I'm going to a specific RFP. Everybody gets that, right? Okay. So, 10, I see 10 is already taken care of, is that correct, counsel?
Yes, Your Honor, 10 is handled, RFP 11 is the next one that has one small piece, and the state's simply asking that Meta respond to RFP 11 on its own, not just referring to number 8. They are seeking different things, and so that's the only outstanding issue on 11.
What we're talking about 9,
Yeah, we were just talking about 9, so 11 is tied to 8, but it does deal with.
Okay, well, 11 is going to be consistent with the 2017 date that the court previously stated, right? So the 2015 would be appropriate. So 11 is, I really see 11 bundled in with what I've already stated with grouping 1 through 8, and then the additional information with regards to 9. So what else is being covered by 11 that's not 1 through 8 and 9, having that goes back to 2017?
Your Honor, I think your ruling on 9 likely resolves 11 unless someone on my team disagrees and chimes in the next 5 seconds. I think the state is fine to move to number 12. And 12 is similar to 9 in the ruling you just made on 9 and marketing, other than we have a U13 issue on 12 as well.
Your Honor, 11 and 12 raise this point that I flagged a bit ago, which is all documents relating to marketing is a very, very broad concept.
Which is why the court made its ruling previously, all, it's not going to meet the standards under Venetian, right? All relating to, so that's why the court was giving the global context. So let's make sure we're on the same little request for reduction. Have you gotten your 5 seconds to see if anyone's chiming in for anything additional on 11?
Yeah, I haven't heard anything, and if they have comments, they can chime in on the Zoom. I don't believe anyone's objected to that to move this along. But
So my ruling for 11 is going to be incorporating 1 through 8 and for 9. And realistically, it looks to me that I'm going to have to address under 13 users. I was going to wait till interrogatory 1, but it seems to me maybe I should segue to interrogatory 1 and then circle back to RFP 12. Does that make sense to everybody?
I think that's fine, Your Honor. Then you can deal with U13 now.
Okay, because, okay. So the court is cognizant of the repeated objection and statement with regards to, based on the policies and procedures, under 13s are not allowed to use the messenger platform. The court's also cognizant of the position of the state that despite that, there might be information in it. There was a particular report document, however you'd like to phrase it, that the state referenced at a prior hearing, that there is some use. So I'm appreciative of the concept of that it may be unauthorized use, but at the same time, a person is a person when I have to look at it for jurisdictional discovery in order to evaluate for the motion to dismiss on personal jurisdiction, right? Because it's impacting someone in the state of Nevada. So, where the court is inclined to go in that regard is that if there is information that is being tracked on unauthorized use, that would at least need to be provided to the state of Nevada, subject to your confidentiality agreement, and without waiving any arguments that this is unauthorized use. You can characterize it how you need to characterize it, but if you have some data points that it exists, despite it not being allowed and being contrary to your policies and procedures, then I can see that that would be state of Nevada only, messenger only, would be appropriate for jurisdictional discovery. That is an inclination. So Counsel for Meta, I think I'm gonna let you go first if you want to on this one, because I see you might have some broader concerns that maybe the court might not have touched upon. If you do, feel free to let the court know. And if this is a situation that I need to address what's currently under seal, you can appreciate I'm dealing with it in a very general sense because of the prior rulings of the court. Go ahead, please.
Well, Your Honor, as long as it's confined in the ways that the court has articulated, it's confined to messenger and it's focused on the state of Nevada, unauthorized use in the state of Nevada, I think we can provide that information in relation to the discovery the court's ordering.
And let's be clear, if you wish to characterize it as unauthorized use, right, so it's not inconsistent with your policies and procedures that have been articulated in the court. I'm not saying that if you have some data that there's some authorized use that's contrary, that you don't need to produce that. You do need to produce the under 13 information with the caveats the court said. I'm trying to be very cognizant of the fact that based on your terms of service, your policies and procedures that have been articulated both in pleadings and here in court, that if there is any such information that it may be unauthorized use. Is that point of clarity, still meet your needs?
That clarity is helpful, Your Honor, thank you.
Counsel from the state, what does that not get you, or does that get you what you need?
Your Honor, I think that's fine as long as the rulings wrapped in together with the court's other rulings, which I understand that is the intent. And then this goes beyond interrogatory number one. I know that's what we're talking about now. Interrogatory one just seeks certain numbers of users in different categories.
I'm tying it into RFP 1, I'm tying it into RFP 12, and a couple others that are coming down the pike, but I would seem to be most helpful for you all is to address it in one and then incorporate it others, and to the extent one of the requests may be more narrow than what the court is going to, or more broad than what the court's going to. Court's ruling of granted in part and denied in part consistent with the analysis addresses that, and then we incorporate it into other RFPs and interrogatories. Is that
Sure.
what your needs, or is there something different?
I only wanted to comment that the under 13 ruling may impact the RFPs a little differently than it impacts interrogatory one, which simply asks for numbers of users in different age categories. So for example, as we talked about last time, Meta refers to under 13 users as U13, and they clearly have documents talking about this. We've also heard testimony that they don't allow them U13 people on their platforms, and that as soon as they find them, they kick them off. Well, as we talked about last time, the state has a right to look into those factual representations, which are just testimony at this point. So some of our requests in the RFP realm deal with Meta's handling of these people and data points related to like how they identify them and how many there are, et cetera. So I just wanted to.
Okay, let me, the first prong, right, how they identify them, I don't see as part of jurisdictional discovery, right, for limited jurisdictional discovery, because that may be unrelated to them, because I don't see how that applies specifically to Nevada and context in Nevada, unless they treat people in Nevada differently, right? Because what has been previously presented is that they're not allowed on the platform, but that they realize that sometimes people do sneak in, that there's a practice of doing something. But taking somebody off the platform, I don't see as relevant at this juncture to the jurisdictional discovery, taking no position on what may be relevant down the road. Okay, so
Understood.
what else is not covered by the court's ruling that you think that the court should be covering, if anything?
Well, maybe we wait until we get to those RFPs, and if I believe there's something different outside the scope of the court's ruling already, I'll comment at that time. I just wanted to kind of note for the record that interrogatory 1 is narrower and just kind of a head count issue versus documents that might involve discussions of treatment of U13 users.
So with regards, now I'm going to circle back to RFP 1, the point that we left, right, the under 13, my ruling on interrogatory number 1 would be incorporated to RFP number 1, and I don't see that you would see a difference there because that's all documents that relate to the interrogatories, right? So there's no broader reach, is that correct?
Yes, Your Honor.
Okay?
That's right.
Okay, so then the next one I get to is RFP 12, right? RFP 12, let's circle back. Okay. RFP 12, I've already modified with regards to 17, consistent with the court's prior ruling 2017, not 2015, so that's taken care of from a temporal component. Since RFP 12 doesn't specifically define U13, but doesn't the court's ruling take into account the incorporation of how that request goes? I've already addressed the issue with regards to all documents, I've already narrowed that.
Yeah, I think so, Your Honor. In RFP 12, the defined term youngest users is actually the same as the U13 group, and so I think it does tie in with this one, but I believe the court's ruling would, on interrogatory 1, as it relates to U13, would apply to RFP 12, and we could do that based on what the court's already ruled.
So then the court's going to incorporate its ruling on RFP 1 as well as interrogatory 1 to RFP 12. Do we need any further discussion on RFP 12?
No, Your Honor.
No, Your Honor. Well, Your Honor, maybe I would just raise one point.
Sure.
This phrase, direct, all documents related to direct and/or indirect marketing, again, it's a very broad concept. It seems to me that if we're talking about advertising, I think I understand the court's ruling, this broader concept of marketing,
It would be a two-pronged concept, the marketing concept that the court stated, as well as the interrelationship, the bump, et
yes, the
cetera,
bump.
issue. That's why I'm incorporating the prior aspects, right? So I'm really seeing direct marketing as direct marketing. The indirect would be the cross-platform that the court's already addressed in RFP 1 and 2.
So it'd be bumps and then advertising
Or
activity.
something similar to a bump. I'm just using bumps
Yes.
as an illustrative example. If there's another method by which there's the cross-marketing, then that would be incorporated in the court's ruling.
Okay, thank you.
Thank you, Your Honor.
Okay, so now let's, I don't see how 13, I think the court's, well, okay, you walk 13. Is there anything else any party needs on 13 or incorporates the court's prior rulings on RFPs 1 and 2, the time and temporal component aspects as well as interrogatory 1?
No, Your Honor. Michael Gayan on behalf of the state, and I'm actually flipping, and unless somebody tells me otherwise, I believe the court's rulings cover everything. I'm already up to RFP 31 and don't see any. RFP 34 is the next one with U13, and I believe the court's ruling would, on U13, would resolve everything in RFP 34.
Right, with
That's Mr.
modification
Hester.
2017 and the modification that if there's not a component for time spent, there's just generalized information, that's all that's being requested. They're not gonna have to go back and create a time spent. For 34. I mean, the document doesn't exist that says somebody was on for 30 minutes, but it only says that this person appears to be an under 13 because guess what, they were doing Polly Pockets. I mean, I appreciate that's really from ages ago, but that type of aspect. Counsel, for state, are you saying something different?
No, Your Honor, I think that's fine. Subject to my comments at the May 10th hearing, if Meta has the data and it's an easy pull, I think that's responsive under Rule 34. They don't have to have a generated report sitting on the shelf, digital shelf, so to speak, but if the data is available to them on the time spent and it was measured and it's there and accessible, then the state would ask for that as well. We're not asking for them to create new information and documents and go back and scour their metadata that they saved on people, but if it's readily accessible.
And what do you mean by readily accessible? Already compiled, or they would have to scour through globally to see if there is Nevada hits? I mean, I'm just trying to get a clarification so we're clear.
You run a query on a database and you pull the information down, kind of like they did for their list of advertisers that we were talking about earlier. You just run a query and there it is. We're not asking someone to go scour through a lot of data, but if it's readily available through a query on a database and it can be pulled and it's stored, I think that's within the scope of Rule 34 and not burdensome. It wouldn't have to already be in a report that says, you know, age categories, average time spent, et cetera. But if the data is readily available, we would ask for that.
How does the time spent, because right, one of their objections tie into personal jurisdiction, right? Numbers of people, right, in all different age groups, yes. The time spent, I mean, because you're saying he's gonna arguing to the court, somebody spends 15 minutes versus 2 hours before they are asked to leave.
Good question, Your Honor. No, it goes to show that Meta is tracking this information. It's watching how Nevadans use their platforms, and then it influences their bumps and other directives, and that's how it all ties together. That, oh, these people need a bump because they're not on as much. It's not, here's the number of daily active users. It all kind of connects with some of our other discovery requests to show Meta's overall plan for reaching into Nevada, growing its user base here, and getting people on the platforms more, and on the platforms more means Meta gets more data about people, where they're located, what they're interested in, what they're doing, more clicks, more ad revenue, all of those things ties into the analysis.
So would those be covered under program services, decisions, and policies? Isn't that the net result versus the underlying data points? Because
Possibly, Your Honor, but the fact that they're tracking this information for Nevada consumers, I believe, bears on the analysis as well.
okay, Councilor Medic, you get 3 points, we heard.
Yeah, Your Honor, I heard two different things. One question is if there's a document that would show this measurement of time, that's one point. The second point, do we have to go into our databases and figure it out? That wouldn't show that Met is tracking it for purposes of jurisdictional discovery. The only relevant issue should be, is there a document that reflects this? If there's not a document, then the fact that it might be subject to something Meta could find in its database if it went back through its data, as Mr. Gayan said, I don't think that's relevant to jurisdictional discovery.
And the court agrees with Meta. And realistically, because you're not tracking it, you're not creating, and you're having to create it, and that would be for purposes of something that they were doing, which would tie to what Meta is actually doing, which would tie to a variety of different analyses for jurisdictional discovery for this court to evaluate for specific. So if there is a report document that has it, needs to be produced, supplemented. If there is not, the court's not requiring the creation of it, because I would find it would not relate to right now for jurisdictional discovery, which is the narrow scope in which this court is evaluating all of these requests. Okay, so that takes care of 34, and I'm incorporating log 1, analysis of logs 1 and 2, the temporal time periods, okay? Does anyone need me to say this each and every time, or do you understand that it's incorporated without me saying it each and every time, unless there's a clarifying point on a specific one?
We understand we're building on the court's rulings, we understand.
Councilor plaintiffs, does that meet your needs as well? Because if you all want me to state this each and every time, I will. I'm just.
We absolutely do not. We understand this is a cumulative process, and the court doesn't need to reach right ground or cover.
And just one more point on document 34, to request 34, Your Honor. It is a request again for all documents, and I know the court has said all is not going to work here. But to be clear,
Courts
Our-
down the street have said that.
yes, Your
Probably
Honor.
appellate courts, yes, go ahead.
Our vision would be, if there is a report, we would provide that report on some annual basis, but we don't have to go and find every document that might reflect this. If there is a report, we produce it.
Intimidation analysis, yes.
Yeah. Thank you.
Okay, so I think the analysis on 34 addresses 35, does it not, councils?
Yes, Your Honor, I think it does.
I apologize, Your Honor, which number?
35, the next one.
Oh, yes, Your Honor.
Okay, so 35 is incorporated, as previously stated. Okay,
I think the same would be true for 36 and 37.
Councilor Menace, do you agree? That finishes off the RFPs. Is there anything else? 36 and 37, the last two RFPs.
I think we can build on the court's rulings, Your Honor, and come up with a workable plan.
Okay. So interrogatory, already ruled on interrogatory one, incorporating everything. Tell me which ones of the interrogatories you think still exist. I will tell you, the court realistically, the terms on all teams, all terms, et cetera, can't be all, right? Because that's not a law, includes whether it's all businesses, et cetera. So what is really outstanding in the interrogatories? I was looking through this, other than you are disputing the term.
Your Honor, I've flipped through it, and I think the court's rulings resolve all disputes on the interrogatories. So unless my co-counsel jumps on the Zoom, unmutes, and says I'm wrong, and identifies where I'm wrong, I would suggest we move to the deposition topics and see if any of those have any live disputes left.
And I'm gonna have a challenge here with my trial, time-wise, folks. I probably had about 10, 15 minutes at most more, but we are about to have closing arguments and jury deliberations with members of our community. I have to balance that with this versus the timing that was requested to go over this. Remember, this was supposed to be just, the court had a few quick questions. I appreciate that's never what ends up happening. However, I have to have some expectations with regards to our members of the community. I can't have them.
Your Honor, to move it along, I flipped through at least the state's chart on the deposition topics. I think the court's rulings are sufficient to allow the parties to move forward. And I'd be happy to hear from Mr. Hester whether he disagrees, but I think we have plenty of guidance from the court on where to go on all the remaining requests.
Your Honor, yes, and we want to be respectful of the court's time. We appreciate the time the court has given us. So I think with the court's guidance, we can likely work things out between us if there's some loose ends here and there.
Because doesn't the custodian aspect kind of overlap with regards to these topics? I was trying to be consistent here.
Yes,
Y'all
Your Honor.
really where you're going. I've already addressed the 2015 versus 2017. You've got that taken
Yeah.
care of.
We've got very
Address the
experienced
scope.
counsel, but I'm sure we can talk through the issues and be respectful of the court's time and not need to come back and take more of your Honor's time.
Yeah, the only ones really I saw was topic 9 and 10, which are the broad interrogatories and document requests. But counsels, I need to ask you about topic 9 and 10. 9 and 10 is the broad interrogatory and document request ones. I think the court's gone through each of those and has narrowed it, but is there anything that Rudy's gonna say? Because the courts, remember, you can't do a 30B6, all topics in our broads, all topics in our request for productions, right? So is there something narrowly tailored that the court has not yet addressed?
Well, deposition topic 9 simply asks for the substantive responses to each interrogatory, so we want to be able to ask a human being about what Meta put in its interrogatory responses. I do think that's appropriate and reasonable, subject to the court's narrowing of things today in the rulings, and I suspect Meta will be supplementing its interrogatory responses, and we just want the opportunity to actually ask a live witness about the substance in those responses. Regarding topic 10, I think all we're asking for in topic 10 is we want to be able to question someone about the factual representations that are made in the RFP responses to the extent there are factual representations. Otherwise, we'll just be asking about the documents that are produced. So,
Right, but my concern with 10 particularly realistically is the breadth of documents produced and going to be produced, right? And without some narrowing of giving some guidance, if we actually do that topic so that the appropriate custodian can be presented for deposition for the jurisdictional discovery, right? Because experienced litigators love little nuances in documents, right? And someone may not understand that they're going to be asked a nuance in a particular document. So I would see that that one would need to be narrowed to what are the topic areas that are going to be sought from individuals, meaning you might get lots of pages, right, on general policies. Well, you may not care about a large number of some of those policies, right? You may only care about certain paragraphs within a larger policy.
Sure, the concern, Your Honor, from the state's perspective is the court has made rulings on information and documents that are responsive and within the scope of jurisdictional discovery. So to the extent the state gets documents from Meta, we would like the opportunity to ask a human being about what the document means in the context of Meta's business and what it's doing reaching into the state of Nevada. What we don't want is them to produce someone, as you mentioned, counsel are nuanced with the documents, but counsel defending these types of depositions are also nuanced and may put up a witness who doesn't actually have information that's helpful.
Oh,
To
that
the
would be
inquiry.
interesting to come back to this court with that one.
Well, and I'm sure if something like that happened, we could maybe just agree to a short supplemental deposition with someone who has information. But in any event, the goal is to have a person who knows something about the documents that we've been provided that the court has deemed relevant to this.
Right, we're gonna go with that, and you all know this is, if you're trying to create custodians that are fruitful for your purposes, and they're trying to provide custodians that, you know, are able to be responsive to the information. If the court were to say it's fine to say, you know, has to have somebody who's knowledgeable about every single document, then that is broader than what would be allowed. They'd have to have some narrow, you know what I mean? If you're providing the generalized topic areas, then some guidance as to where some of the documents are so that a proper deponent can be provided, right?
I'm sure we can meet and confer
I'm sure
with
you
Meta
can, yeah,
and work out something reasonable. We're not looking for, 50 different witnesses to be able to talk about every single document, but to the extent they can find a witness, and we just haven't engaged in those discussions yet to know who potential designees might be and what this, if it's one person, two, or even more, I don't know. So
So you're
we're
seeking-
happy to work with them and not be doing what the court is concerned with.
Since it's here for the court to resolve today, that's why I'm asking. Are you requesting a ruling by the court on number 10, or shall we just leave that you all will do a meet and confer and give you further guidance and you come back to the court on that one?
Well, since Meta has a motion for protective order, I'll obviously.
That's
let
why I'm
them
asking,
weigh
because
in.
there's both protective orders and motions to compel. So
I mean, it does seem to me, Your Honor, that the topic is too broad insofar as it would expect a witness to be able to discuss every document. I had understood the topic actually to be asking about how did you go about looking for the documents and what did you do? There's going to be representations, for instance, that certain documents don't exist. And we're certainly prepared to have a witness who could explain this is why we don't have a document on this issue.
So it seems to me you all are potentially, are you reading number 10 the way that Counsel for Med is reading number 10? Are you reading number 10 that someone would need to be knowledgeable on the contents of documents that are produced, or documents, the process of producing documents, or both?
Well, Your Honor, I'd ask my co-counsel to weigh in. I mean, I think we could limit 10 to the process of responding to the RFPs, the factual representations, and how they went about locating the documents. I think that would likely resolve counsel's concerns. So unless my co-counsel chimes in here in the next couple of seconds, we'll agree on that and thank the court for its time.
Is that an agreement under DCR 7.50 that you all have made that agreement, or are you requesting a ruling by the court?
No, we can agree to that, Your Honor.
Meet your needs?
I have not
Have I
heard
given
from my
enough time and
co-counsel,
time?
so we're agreeing, yes.
Okay.
They have their 5 seconds.
Okay, so I understand that all parties have not requesting anything else from the court on the RFPs, the ROGs, and the depot designations, correct? So all discovery matters are being concluded?
Yes, Your Honor.
Okay,
Yes, Your Honor.
so your request for coordination. I'm gonna need some further explanation of what you're really seeking. And I appreciate there's different views on how that local rule shall be interpreted, okay? And I could, at least some of the people in this courtroom, most, are familiar with maybe the real water cases and how coordination was dealt in that way, which is very different than what seems to be under coordination you all are seeking here. The explanation of that is for those who may not be familiar, series of cases in which discovery was coordinated. So the concept of having certain scheduling orders, each of the various trial judges pick their own trial dates, actually handled all of their own motions, handled many of the various discovery disputes subject to handling what really needed to be done after reports and recommendations, etc. However, here it appears you all are 90-some-odd% towards consolidation with a lot of caveats and things and giving various options which you may wish to do down the road, which kind of doesn't necessarily give the court the clarity of what you're really asking this court to sign up for, and are you going to be requesting, I'm going to use the term currently utilized, special master, although that's hopefully changing somewhere down the pipe, but that's the current term I'm supposed to use. That's the current term I'm using. Because you can appreciate, it's lovely to see you, but if we're having these type of discussions in 3 different cases, right? And this is only the first round, not saying it's not in any way any hint to any perspective ruling, this court's not, I'm just saying. If I were to take this, it's lovely to see you, how many times I've seen you at this early part of the case, but you can appreciate that we would need to ensure that you had all of your needs met, and maybe needs to be some designation of a case complex and a special master. So walk through what you're really asking, because realistically it's like, well, if we change our mind and we kind of want you to do 1 trial maybe, but we may want you to do trials, we might want you to do 3 trials, we may want you to do discovery, we may not want you to do discovery. I appreciate you all gave yourselves a lot of wiggle room, but it doesn't really give the court a lot of understanding of what you're asking this court to sign its name to.
Your Honor, Michael Gayan for the state, we certainly understand, from our perspective at least, the practical implications, many of which Your Honor just laid out. So the way we view it is, it is akin to consolidation for all purposes except for trial. The parties are not asking for a consolidated trial, although...
And can I step back for 1 second? How about all dispositive motions? All motions eliminate, right?
Yes.
How about issues with regards to trial scheduling, right? And how about any potential bifurcations, maybe internally, topics, issues, law of the case type issues?
Yes.
I was spending a long time walking through what you all really needed and what would be all the implications. Go ahead, please.
Yes, Your Honor, I believe that would all be in this department if the court signed off on the party stipulation. What, at least from the state's perspective, we would not intend to ask this court to handle all discovery matters. It's been a little while since we proposed it with Meta, but we do, from the state's perspective, think it would be entirely appropriate to appoint a special master to preside over the discovery portion of this case. This is business court. The court is a trial court, has many other responsibilities, and due to the discovery issues that have taken up, I don't know how many hours already of this court's valuable time.
I'm here for you, but it's a practical matter.
You have many other matters, and I'm sure there's more being assigned to you every day, so it's, we respect the court's time. I think the appointment of a special master makes a lot of sense. It may even make sense in the immediate future, just on the messenger case, due to the ongoing jurisdictional discovery. It might be helpful to have someone like that appointed before the 30B6 deposition to resolve any future disputes. But, you know, these are some logistical issues we haven't gone into detail with Meta on, but at least from the state's perspective, we do not expect this court to use its time on all future discovery disputes in any of the 3 cases, should the court sign off on the proposed stipulation.
because you realize what paragraph 9 says, right? At the time of any trial, in any of these 3 cases, each party agrees that any such trial should be before Department 31. That means Department 31 is doing all 3 trials in that first part, right? It even says my name, it even says my department number, but then it has a but each party reserves the right to argue any position regarding coordination or consolidation for trial. So then the first sentence appears to say, they're all in front of you, Judge Kishner, Department 31, and the next part of the sentence seems to say, however, we can change our mind, and maybe we're not gonna really want coordination, maybe we're not gonna really want consolidation, stay tuned, we'll see what we want. And then I went to paragraph 12, right, for the avoidance of doubt, statement may agree with the court's approval, and so you have the documents, right? And then the way you want these documents is only certain documents apply to 1 case, 2 case, or 3 case, which appeared to this court.
Let me see.
Compared paragraph 9 to paragraph 12, I'm trying to figure out a word other than say the word inconsistent. As a sophisticated litigator, so I really wasn't gonna call it inconsistent on you, but I can't think of a better word, so I'll say inconsistent.
We did spend a little time on the language here, and let me see if I can articulate it. I'm happy to have Ms. Peterson or anybody from Meta's side chime in. But the idea is to have this court preside over all 3 matters. They are separate for purposes of trial, but due to the overlap of issues.
Wait, for trial meaning this court tries all 3 cases?
That's correct. And the purpose of the language after but in paragraph 9 was each side reserves the right to argue that they should be tried together, either all 3 or grouped some other way. I think that's what the but language was intended to do, not that we could send them back to some other department later, but that this court would retain all 3 through the conclusion of all 3 cases. It's just an open question of whether either side could argue later for efficiency's sake, depending on all sorts of things that might happen between now and trial, that say 1, 2, or maybe all 3 could possibly be tried together.
But that's where, I mean, so is that subject to bifurcation of issues? Or is that, see, because once you get to coordination, and I am very appreciative, and I really don't have the time, nor do you all want an analysis of the local rules, changes in what may have been intended versus the plain language. And since I'm going to be a former chairperson of the Rules Committee, I might have a little knowledge on that. But at the time, anyway, but I'm just saying, versus the way it is in practice, okay? And coordination in practice, as those who did real water, or if you go old school to Hep C cases, right, was usually a mechanism tied normally just to discovery, right? Then kind of stop discovery somewhat like that. And I appreciate the language says something other than less and shall hear all. I get that language. But so would it be down the road that then they wouldn't be coordinated, or they wouldn't be, and then somebody would potentially seek consolidation? Because if you're just talking trial purposes, right, that's usually bifurcation, right? Whether it's bifurcation on issues, bifurcation on claims, bifurcation on parties, right? And that would go to the trial judge. But then are you trying to basically say that you want to just leave it open towards the end, whether or not there's 3 separate trials of X amount of length?
Yeah, Your Honor.
As a business court preference, taking into account EDCR 1.90 and what the percentage of trials that are supposed to be done within 2 years? And the percentage of trials, right, they're supposed to be done within 3 years with the business court. I'm just trying to get an understanding of what you're really asking.
Yeah, Your Honor, I think what,
Then I'm gonna ask you.
the way it's described in the stipulation, it does sound more like consolidation for all purposes except for trial, and we'd have 3 separate trials. The goal is to have, to avoid inconsistent rulings on substantive issues, either on a motion to dismiss, jurisdictional issues, dispositive issues down the road. And that's in paragraph 8.
We had even reserved 3 sets of potential jurisdictional discovery disputes, right?
Potentially, I mean, from the state's perspective, if the court in the Messenger case, this court finds jurisdiction over Meta for Messenger. I would have a difficult time imagining Meta prevailing in a jurisdictional defense in Facebook or Instagram cases, but those are hypothetical at this point. I suppose we'll see what happens, but you know, Meta approached the state with this, wanting to avoid inconsistent rulings. The state agreed. We were actually about to approach them about the same thing, and so those cases are a little behind this one, but just on Rule 12 motions, service has been accomplished, and we're just working out briefing deadlines for those so that they're sitting there waiting to have something happen. And the goal would be to have this court preside over all three and ensure consistency for the parties. And as I said, discovery would go elsewhere, and we would not burden this court with that. That is from our perspective. Haven't heard from Meta on that yet, but that's certainly what the state intends.
Counsel for Meta, who's taking this one?
Good morning, Your Honor. Tammy Peterson again. I largely agree with what the state has represented this morning. We're certainly trying to have this court decide dispositive motions. If it ever got to the point where we're talking about motions in limine, yes, this court would be deciding motions in limine.
But then would the court be doing all three trials, 2 trials or 1 trial? I mean, all 3
I will
cases
say-
regardless of how the trial request comes to the court.
Yeah, I would say it's a little difficult for us, and I always spell this out in the stipulation, it's a little difficult for us to conceptualize a trial right now, because of course in the Messenger case, we filed these motions to dismiss. We don't think there's any personal jurisdiction. It was the state, as you pointed out, who filed 3 separate complaints. We are certainly intending, and I think that was sort of hinted at in this stipulation, that we will be filing motions to dismiss that Facebook case, that Instagram case. So when you say conceptually, how is this trial gonna work out? I mean, I will tell you right now, Your Honor, if I believe we have a basis to file a motion to dismiss those other cases, it's really hard for me to conceptualize that there will ever be a trial as to Meta. So I just want to kind of couch that here, but we were certainly trying to anticipate at a later time if there is some sort of case that is left over in any of these 3 cases, that the parties would want the option to try to consolidate that into one trial. But yes, the answer is we are seeking to have you make all of the rulings. Mr. Gayan a while ago did ask for a special master. We thought that was incredibly premature because of the issues that are pending right now. We haven't even filed our motions to dismiss in the Facebook or Instagram case, and we will be doing that. So all of these conversations are a little bit premature, so that's why
So is this premature? Because realistically,
Well, except, Your Honor,
because the
what we don't
challenge, here's
want,
the challenge, counsel, realistically, I don't think you answered the question about whether or not you were saying that you'd want Department 31 doing whatever number of trials, whether it's 1, 2,
I think we
3.
would.
Okay. Because
We would, Your Honor.
we have to have the judge doing the motions, eliminating dispositive
Right.
motions, do a trial,
Yes.
general, I shouldn't say that. Subject to, who knows if I'll have business court tomorrow, you know what I mean?
Right,
Everything
no,
can
we
be
were
reassigned.
asking for Department 31 to do the trial. What I thought you were asking me was, are you asking me to do 3 separate trials? And I can't say that right now.
What I'm trying, the way this language is to argue then about coordination, consolidation is like, okay, this is our temporary, we want coordination, but down the road we might change our mind and we want it to go back to other judges, or we might want judges to have 3 different trials, because remember, the coordination rule actually does not include specifically the trial, right? So it could be that you want one department to do it up through motions eliminated and then 3 separate departments for trial. That's not generally any situation if all the judges still are remaining on the bench, right, subject to retirements, other things like that, right? It's not usually the most effective means by doing something, right? Because most people want motions eliminated to be heard by the trial judge in larger cases. So I wasn't sure what you were reserving out here. That's really partly where the court was going. And then the 3 aspects with jurisdictional discovery, it seemed to this court that if you're having issues that you want to address in motions to dismiss, does it make sense to coordinate now? So, because then are you saying you want one court to be handling all motions to dismiss and any potential decisions on jurisdictional discovery subject to those motions to dismiss? Or you want those handled by 3 separate courts, because currently you've got 3 separate courts?
We're trying to avoid inefficiencies and inconsistent rulings, and that is one of the reasons
Sure.
why we've asked this court to handle those decisions, the decisions on any motion to dismiss, the decisions on any issues about jurisdictional discovery. If anything remains, it was certainly our intention that this court would be trying those cases. That was our intention. But again, you're asking a lot of things that we don't necessarily think are ever going to happen. So we're trying to kind of balance that, but that was the intention, Your Honor, to have this court handle all of those issues. And I'll just say, I read Rule 42 as and I read our local rule as really, our local rule can't be inconsistent with the Nevada Rules of Civil Procedure.
They can
Right.
supplement, they cannot be inconsistent with.
Right, they can't be inconsistent. So I've always thought of coordination as basically less than consolidation for all purposes. That's how I've seen it. I know it can be managed differently, whether it's discovery on certain issues, whether they're still separate trials, but we have all thought here that this court should be handling these 3 cases. And that is, frankly, to promote the guidelines in Rule 1, speedy, inexpensive, and it's efficient, and it gives us predictability.
Sorry, I was double checking 2.51B2. And because your paragraph 12, in wanting to file certain documents applying to only certain cases. Right, so 2.51B2, just in case you don't have it memorized, documents filed subsequent to the coordination shall list all case numbers and captions, with the lowest number appearing first, and the clerk shall be provided with sufficient copies for each case number so listed, okay? And the reason why usually coordination involves multiple departments, okay? Take real water, hemp C case, right? Because then you have to file them in all the departments, so all the departments have the information. And subject to when you get to trial, well, it depends on the scope of the coordination, right? But here you're asking applies only to, when you get into each of the case numbers. So what is the request?
So it's still meant to be, everything's filed in the lowest case number, okay? But the reality is, we're gonna file a motion to dismiss, like this Facebook case or this Instagram case. Just for clarity, we're trying to say, hey, this is our motion to dismiss the Facebook case. That's all this was intended to do, but everything is gonna be filed in the lowest case number. That was our goal.
Because you understand, normally coordination doesn't involve one department coordinating cases within that same department. That's usually consolidation. You know what I mean? And I appreciate the distinction, the caption, but it's consolidation with bifurcation. Possibly what you're looking at certain things, so. Okay. Do you oppose the concept of a special master, or you agree with the concept of a special master? And I'm not making any assumptions going
Listen,
forward.
that is a difficult thing for me to agree to at this time, but I can say this, I am open to the concept of a special master. And certainly, again, Your Honor, I can't emphasize this enough, we're going to seek to dismiss these other complaints, but I certainly would say if anything survived, after that, I think we would absolutely be open to a special master.
Right, but let's go to the reality world, right? If you don't have an extension in your motion to dismiss, and whenever your time date is, that's gonna be coming up pretty soon, right?
I understand that.
So you're asking for coordination before filing a motion to dismiss, so then this court would have to evaluate, I mean, I'm not trying to have you all give away your strategies and,
Right.
okay, and timing, things like that. I'm looking at a practical timeline. I heard counsel complain that they didn't agree to extensions until this one worked itself out, right, with a ruling on a motion to dismiss. Given where you are currently in jurisdictional discovery in this case, which is in case correctly before this department, it's not gonna be finished up in the next 30 days, right? But I don't know what your current extensions are or whatever with regards to service and having to file your motion to dismiss. But if it's happening within the next 30 days-ish, right? And I don't care if I say 30, I could probably go up to 60, right? Given where you're at, you know, somewhere in the next 30 to make it safe, right?
Yeah, I mean,
It's-
we've appeared in both the Facebook and Instagram cases, those clocks are currently running, if that's your question. You know, Your Honor, perhaps I overthought this in the very beginning, because I looked at the local rule, and the local rule says, hey, consolidation is premature before you file an answer. And we did not intend to wait for this time and have 3 separate rulings, and I thought the state was agreeing to that premise as well. So we did want to consolidate for less than all purposes here before this court, and that was the goal.
What's your timeframes on your other 2 cases for when a responsive pleading, i.e. if you're going to file a motion to dismiss for personal jurisdiction is?
Well, I believe we have an extension on the Facebook case, but I don't think the extension has been particularly quantified.
Okay, understand, I'm only looking at this from a timing standpoint.
Right,
I have to
well-
evaluate whether coordination is appropriate now, or I should revisit this a little bit later, after there's a determination on the motion to dismiss. Should the court be doing that versus now? And what's in the party's best interest on the timing when the court should evaluate coordination?
Yeah, Your Honor, I think we were trying to avoid filing a motion to dismiss before 2 other judges and having potentially inconsistent rulings there. I think that's what we were trying to avoid. So when you ask me what the timing is, on the Facebook case, we've been given an extension.
Okay, so I don't know if that's an issue or a non-issue, honestly, because I don't know you're behind the scenes in the 2 other cases. I don't go looking at other departments' cases, right? I have enough on my own docket, and, you know, deal with the issues that are before me, as I should, right? So that's why I was asking. If it's a non-issue because those aren't going to come up, then that's one thing the court needs to evaluate. If that's going to be an issue where this court may be being asked to rule on a second or third motion to dismiss while this one is pending, and this is not any substantive ruling, this is just a question to evaluate the timing which the court needs to do under the EDCR and evaluate the timing of a coordination request, right? The same way the timing of a consolidation request is, does that make sense or does it stop your case? Now, I appreciate this unique circumstance, we've got the same party, so I don't have to worry about some third parties in one case that aren't in other cases, right? And them being impacted, but does this make sense now in light of where your timing's at?
We think it does, Your Honor.
Okay. Counsel for this state, do you think it does as well?
On the timing, yes, Your Honor.
Okay.
I guess a couple of short comments. I know the court's busy, but on the special master, I do think it would be appropriate if we had someone in place before the deposition, because just a reminder, on the motion to dismiss briefing in this case, it's all on hold until this deposition occurs, and what we don't want to have happen is disputes in the deposition that turn into motion practice, and a second deposition, and all of a sudden the motion to dismiss is pushed out even further. It'd be good to have someone available by phone to rule on that. We can certainly meet and confer with Meta and file a motion if we have to, but I just want to make that comment on the record. And the other question I just realized sitting here as we've been discussing this, we did not address a deadline for Meta to provide the additional information the court ordered on the discovery disputes. We would ask for 30 days, but I think that we need some kind of directive on the timing so we can keep this process moving.
Which is part of the reason why the court didn't yet give you a timing, because I need to see this coordination to see if this is an issue, which magically is, you might have understood why I was asking about whether the other motions to dismiss were coming forward in the next 30 days, right? And I need to see where your timing is, because there is some overlap here. And well, I guess I'll address your 30-day issues, 30-day meet the needs of Meta.
Your Honor, I just can't commit to it today because there is still some work to be done between us in terms of exactly what needs to be done. We have to agree on custodians. There's some time here. We can undertake our best efforts. I just don't want to commit to the court that I know today we can do it in 30 days because we have to translate the court's guidance into exactly what's going to be produced in
There's an order,
responses. to civil
court order,
requests.
GDCR 7.21, you will
We
provide
have-
an order. But
I'm sorry, Your Honor, that I meant the court's order,
No
but
worries.
in other words, it requires a bit of time for us. I think I heard the state say they want to have an agreement on the custodians. It just takes a little bit of time to do all this. I just don't want to commit right now without consulting with my client and understanding what's going to be at stake.
Well, Your Honor, we'll make ourselves available to meet and confer and move it along, and I suppose if
I'm gonna say 45 days, and if anybody's requesting anything longer or shorter, you need to come back before the court, okay?
Thank you, Your Honor.
Meet the needs of both parties, gives you some extra time, it gives you realistic time, deadlines and different things like that. Here's where I'm going regarding your coordination. The coordination, I'm inclined to defer this. Because the challenge I realistically see is without having any understanding of what is going to be the tie-in for other motion practice. If you all had an agreement, either A, you need to file your motions to dismiss by X date, or B, you have an agreement that, that X date is way in the future, then this might make sense. But realistically, asking the court to coordinate something, not appoint a special master, at least on one side, and yet not have a scope of what this court is really being asked to do based on what was presented in that. Ultimately, potential trials, one side says may or may not include this, the other side, one side says they will potentially, the other side says no, they're out on a motion to dismiss. So if you think it's going to a motion to dismiss to coordinate things when there's a pending motion to dismiss for personal jurisdiction, you do appreciate a little bit of the irony of that one, right? You're asking me to take on more on something you said that I should never have in the first place. That's what I meant by the irony. You are. You are. I'm going to really, one way of just, I think I might need to evaluate this for a little bit of time, but since no one was really getting my need to evaluate a little time, I was kind of just going to the direct and heart of it, of why I'm thinking that is, you're asking me to take on more, which the court's perfectly fine with taking on more. That's not the issue. But does it make sense for this case when you are procedurally in the two other cases without a clarity of what is going to be the step? I mean, and I'm not suggesting that you all should have an agreement one way or another to put things on hold or to not put things on hold. That's not this court's role, and I wouldn't have a position on that one way or another. Just when I'm looking at what you're actually asking to do, there's so many ifs and contingencies that I really don't see it falling within the coordination for this court to be properly able to evaluate your stipulation and to coordinate these cases in what would really be a articulable and feasible manner. There's too many
Your Honor, I think,
caveats and things like that. So, I mean, I'm not like saying I won't, because I see all the practical things, and obviously you all know I've taken on lots of consolidation and coordinated cases. That's not the issue. It's just, it seems to me there's a lot of strategy going on right now that people might need to figure out what they want to do and then make a more articulable, because if this was to be coordinated, just to let you know, you're getting a special master. I mean, that's a reality aspect, because it's wonderful, I mean, it's excellent pleadings, okay, very detailed, very organized, but this is the type of thing that makes more sense to be addressed in our complex cases here in Nevada through a special master, so that the court can address the things that you really do need to address, right? And if there is a whole series of different depositions, et cetera, I've made myself available for other depositions. It can't be on a daily basis, given the rest of the court's docket. It's just not practical or feasible, and you all have other cases in this department you wouldn't want me to be doing it for your other cases anyway.
Your Honor, Michael Gayan, to say, I think based on your comments, the parties can put our heads together again and revisit the issue down the road. I think that's appropriate, and I know Your Honor has others waiting.
I mean, I don't even have a date when you want me to hear the motion to dismiss yet, okay? Yet you're asking me to coordinate and do other things for 2 other cases. That just doesn't seem practical at this juncture. I mean, if you want me to revisit it, we'll set up a special setting and I can discuss this more with you now that I've kind of given you the thoughts. That's not, so it's up to you. Do you want me to make it a ruling today that I'm going to defer, I'm going to, I can either deny it without prejudice, I can say I'm deferring it and you all will pick a new date in which to discuss it, or I can see if maybe you all are revisiting this idea and maybe you want a special setting to discuss this further now that you've at least heard some of the court's statements and you've heard where you're going on some of your jurisdictional discovery. Those are all options, and if there's some option I haven't mentioned, you can say that as well, but I am gonna have to say pick one now because you can appreciate.
Your Honor, Michael Gayan, for the state, my proposal would be that you defer a ruling, the parties consider your comments today, we meet and confer, talk about it, and maybe within some reasonable period of time, we submit a joint letter if we'd like a setting to discuss the issue
Should I
further.
just pick a date in July for a setting and then give you all that if you decide that it should be vacated because there's not a need, then I'll find out if it's withdrawn or need a ruling, would that maybe meet your needs so that way you have a date certain?
That sounds like a great idea.
Council Pimento, what's your thoughts?
Yeah, that's agreeable to me.
Maybe avoid the week of the 4th. Unless Mr. Hester wants an excuse to come out here on the 4th.
You want July 10th, 8:30? Or do you all need a special setting, should I put it,
Yes.
because none of these go 5 to 7 minutes? I'm gonna get Judge Gonzalez's clock, I need Judge Gonzalez. Here's what I'm gonna do, I'm gonna put it on for July 10th, the reason I'm gonna put it on for 8:30, because I am currently in trial, I might find out something different tomorrow. You all aren't involved in that case. So I'm gonna put 8:30, but I'm gonna say that you all are gonna notify the court, well, I can say a week in advance, well, I'm gonna say by July 1, whether or not you still need that hearing and how much time you need for the hearing, then we might change the time. And who knows, we might even change the date. That way you at least have a date certain for now. July 10th, 8:30, with a letter to the court, a joint letter to the court, or a stipulation, whatever you're doing, by July 1, end of business day, as to the amount of time you need for said hearing, and if you are requesting anything different or to vacate the hearing. Does that meet the parties' needs?
Yes, Your Honor, that works for the state, and Ms. Peterson just reminded me that we technically still have a motion to dismiss hearing date in June. That's going to move, obviously, in light of everything we talked about today. I think the parties can handle that via stip and order later. We don't need to take the court's time with that today.
Right, didn't you all say that you're going to want to do it, but that we needed to find out the date for the hearings and what was the court's rulings today, so.
Yes, but you did enter a hearing.
I entered
just to
July,
keep track.
I entered June 18th to
Right.
give a date, so that it's,
Right.
from a court standpoint, it's better to have a date than to move a date than to leave something up in the ether and then try and find a date for you all.
Yes, we just wanted to mention that that's there, but that will be moving, and we'll discuss between council and submit a stipulation in order to the court to consider.
And who knows, you might ask me for, okay, but I will need an estimate of time of how much you need for that motion, please, so that we have realistic estimates, so we can balance it with other matters on for the day and trials and things like that, okay?
Thank you, Your Honor.
Appreciate it, thank you all for
Appreciate
your
your
time.
time.
Thank you, Honor.
Have an enlightening morning.